I missed him so much.
You take a gun to school and you will be held accountable.
By her with a combination of pharmaceutical substances that were mixed in with an alcoholic beverage.
Richard Masten, the executive director of Miami-Dade Crime Stoppers, took a dramatic stand to protect the confidentiality of a tipster in 2014. During a court hearing in Miami-Dade County, Florida, Masten refused to comply with a judge's order to hand over a document that might have identified an anonymous tipster. Instead of providing the document, Masten swallowed a piece of paper in open court, which reportedly contained the information that the court was seeking. Masten's actions were a form of protest against what he saw as a violation of Crime Stoppers' pledge to protect the anonymity of individuals who provide tips to help solve crimes. As a result, he was found in contempt of court by Miami-Dade Circuit Judge Victoria Brennan and was sentenced to 14 days in jail. However, his sentence was later suspended, pending further legal proceedings and appeals. Tyler Terry and Adrian Simpson, known as Chester County's Bonnie and Clyde, were sentenced to life in prison without parole. Authorities say they were involved in several murders across 3 states and led deputies on a dangerous chase in Chester County, even firing at them. After Simpson was arrested, Terry escaped, prompting a week-long manhunt that terrified residents. Both faced the victims' families and accepted their sentences. The search, centered in Richburg, was one of the most expensive in the county's history.
I just want to let you know that my heart aches every day. I missed him so much.
One by one, the families of the victims shared their grief, forever impacted by the actions of Tyler Terry and Adrian Simpson. In May 2021, the pair earned the nickname Bonnie and Clyde after allegedly killing Simpson's husband and then committing a series of crimes across South Carolina, Tennessee, and Missouri.
He threw away lives as casually as we throw away a wrapper from a piece of gum.
After returning to South Carolina, Tyler Terry and Adrian Simpson led police on a high-speed chase, during which they fired at the officers. Simpson was captured, but Terry managed to escape on foot, prompting a week-long search through the woods of Chester County.
More than 600 law enforcement officers at the state, federal, and local level participated in this investigation and the hunt and capture of these individuals.
Life in prison.
After the sentencing, Tyler Terry remained silent, while Adrian Simpson chose to speak out.
Words cannot express how this has affected myself also, and how much I wish I could rewind time and change what happened.
Simpson's own sister rejected her apology, stating that she believes Simpson is just as responsible as Tyler Terry for their crimes.
You know, Adrian got what she deserved. I mean, she chose this path.
The pair is expected to appear in court in 2 other states, but these hearings are expected to be more of a formality, allowing victims in those cases to speak and share their stories. Prosecutors chose not to seek the death penalty in this case because death penalty cases often involve lengthy appeals, which can make it harder for victims and their families to find closure and move forward. Joel Greenberg, the former Seminole County tax collector, appeared in court for a final hearing before his sentencing after pleading guilty to several federal charges, including wire fraud, trafficking of a minor, fraud, and stalking. During the hearing, the judge hinted that he believed Greenberg deserved a longer prison sentence than the sentencing guidelines suggested, which is more than 10 years. The judge's comments indicate that he may consider a harsher sentence due to the severity and range of Greenberg's offenses. Greenberg's lawyer argued for a lighter sentence, emphasizing that Greenberg had cooperated extensively with federal investigations, assisting in cases against 24 individuals, including some involving corruption, election fraud, and sex crimes. 5 of those individuals have already been charged, and 2 more indictments are expected soon. Despite this cooperation, the judge seemed inclined to impose a stricter sentence.
I'm not trying to be rude, I'm just in the middle of the sentencing right now, so I can't make any public comments. I can tomorrow. You can hang out with me, you can follow me to Bennigan's, whatever you want to do.
Joel Greenberg was sentenced to 11 years in federal prison on December 1st, 2022. Ricky Passmore is currently on trial after police reported that he broke into his ex-wife's home in Clover, carrying a samurai-style sword. He allegedly pushed her onto the couch and threatened to kill her if she moved, while he searched the home for her black boyfriend.
When you spoke to Ricky about your relationship with Chip, was any mention ever made of him coming to your house?
Yes.
Can you describe that?
In that conversation, he said, let that be there when I get there. We'll see who the real man is.
And what was your response?
I told him, don't come to my, Ricky, don't show up at my house.
So what did you do when they come into the house?
I went to get off the couch. The first thing Ricky said to me is, where is Chip? I said, he's not here. Where is he? I said, it doesn't matter, he's not here. I said, what are you doing here? And I said, as a matter of fact, where's my phone? And I started looking for the phone. That's the point where he pushed me down on the couch, produced the sword, and said, you move, you die. He proceeded towards the hallway. I'd say about 3 steps into the hallway. He turned around and told his twin brother, she moves, she...
Your testimony is that you went out on the porch, right?
When they were leaving.
So you got off the couch.
Yes.
And my question is, nobody touched you with a sword, right?
No.
And in fact, the sword never touched anybody.
No.
Nothing was torn up in your house, right?
No.
I asked her, I said, well, there's plenty of white men out there to help you pay your bills. Why didn't you find one of them? She said, because white men ain't. I said, okay, is this what you're telling our son? I mean, imagine this. This conversation went on. By the end of the conversation, she agreed she'd give me away.
All right.
People want to sit here and call me a racist. I got nothing against a black person that don't hurt white people. Nothing. But I do have some issues with things that's happening in my life. If I had been going over there with the intention of hurting Chip, I would not have called and gave Julia time to have law enforcement waiting on me when I got there. I would not have called and gave him a warning so he could have some of his little armed thugs waiting on me when I got there.
What happened when you got close?
We pulled up in front of the house, the trailer, right up to the curb. We didn't park down the road, try to sneak through no shadows, hide around back, and none of that, ooh, here comes a burglar thing. We parked right beside the curb, up under a security light, right in front of all the neighbors. I got out, walked up, knocked on the door.
Did you have a sword with you?
Yes, I did.
Why did you have a sword?
I carried the sword with me to send Chip a message. I told Tara that if it come to it, then I would get violent with him to keep him away from my children. I was trying to keep it from coming to that by sending him a message. Tara told me that he had been sleeping over there. Now, if I'm seeing a woman who has legs, who has children by another man, and I know this man is subject to show up at any time with God knows what in his hand, I'm not going to sleep. I'm not going to be hanging around the house. I'm going to tell her, you got to come to me.
He was arrested and charged with violent threats and related crimes, with multiple records indicating his involvement in serious offenses. 3 juveniles in Rock Hill, South Carolina, have been charged with weapons offenses after firearms were found at 2 high schools and a middle school on consecutive days.
Your Honor, he is in detention on charges of weapon on school property, docket number 22
22-483, unlawful carrying, 22-482, possession of a gun under the age of 18, 22-484, resisting arrest, 22-485, and carrying or displaying a firearm in a public building, 22-486.
In person, I witnessed some suspicious activity between various groups of students that myself and my partner had been watching for issues. I returned to my office, looked at the video surveillance system that we have, watched the interaction that I witnessed, and then some interaction before and after that. It was extremely suspicious. I believe something more was going on. I believe some form of contraband was actually on campus. Administration did attempt to search. He refused that and attempted to leave the school. Administration then called me on the school radio to assist with that. So by the time I reached the front office, I had already gone into a front conference room along with, I believe it was 2 other staff. He was refusing both his person and his backpack to be searched. Attempted to discuss things. He was eventually allowed to contact his mother, who did come to the school. Administration allowed the mother to search the bag. The mother searched the bag and immediately put the bag on her back as if she was trying to leave the school. I took the bag from her searched bag and located a loaded 9mm handgun in the bag. Right about that time, I actually fled the school. My supervisor, Lieutenant Ayers, was on scene attempting to help me with the investigation. They actually met in the hallway. Lieutenant Ayers attempted to stop me. The 2 ended up in a scuffle, eventually broke free and was able to run. He was found later during a canine track.
Thank you, Your Honor. Your Honor, in this matter, Your Honor, this juvenile is on probation. He was last before the court in November of 2021, and at that time, he was for disposition on several charges, including failure to stop for a blue light, assault and battery, high and aggravated nature, and possession of a weapon during the commission of a violent crime. Your Honor, that offense also involved use of a hand. He was given an indeterminate sentence under the buyer's order, and Your Honor, it's my understanding that he was released released into the community on probation in June of this year.
Well, then, based upon my review of the file, as well as the arguments, along with the admission that there is in fact probable cause, I do in fact find that probable cause does exist and that the juvenile shall in fact remain detained at this time.
Tip line, I can't stress it enough, to reach out if you see something, say something. In 2 of these incidences that we're talking about today, that's exactly what happened. It was tips, it was surveillance that led to this discovery before something horrific happened.
The problem is multifaceted. This isn't just a problem that the school has or a problem that public safety has. It's a community problem, and the problem starts at home. This is where it needs to be addressed in the first instance. Parents need to take responsibility for their children. Parents need to know what their kids are up to, and parents need to actively engage with their kids to find out whether they're carrying a 9mm to school. How does a child go to school with a 9mm and the parents don't know about it? We need to be as active as we can in making sure that kids understand this isn't small ball. If you bring a to school, we're going to take it very, very seriously. You take a gun to school and you will be held accountable. We will not just treat this as a minor problem. It's going to be treated as a major problem because it is a major problem.
2 of the teens appeared in court and will remain in custody for the time being. Robert Land, 18, admitted to shooting a deer at night and then dragging it away to retrieve it later.
Sir, on November 3rd this last year, Mr. Land was driving down Martin Strait Road. A deer crossed in front of him. He stepped out of the vehicle, shot the deer in the middle of the road with a single barrel 12 gauge, and then drove off. He later came back with a friend. They drug it 2 houses down from the location, and then he left again. And we got there. We got the call because of the resident where he shot the deer, called DNR, we responded, got there as soon as his brother was coming there to pick up the deer, got him to call Mr. Land, he came back and confessed it.
Pursuant to the statute, his car got seized. He had not long afford to purchase that car for $2,500. And the statute says what it says. He has got to give up that car once he is arrested for this offense. There's really no way to argue about that. He doesn't have the ability to pay $1,800 to get a car back. I think we all know that $470 is going to be in General Sessions Court. There's no way he's going to be able to pay that. But he spent a night in jail. He had to pay a bondsman to get out. He lost his car. That's a $2,500 fine right there. Your Honor, he did a stupid thing. This is a teenager who saw a deer. He had a gun got seized to. So he learned a very valuable lesson that night. And I don't think you have to worry about him pulling off on the side of the road and shooting a deer anymore. So I ask you to consider him being punished enough for doing a night in jail, paying to get out of jail, and then losing his vehicle. And I ask you to give him time served and let it go on.
All right, thank you. Mr. Lane, anything you wish to tell me? So understanding the potential penalty as well as the underlying crime charge, how do you plead? Guilty.
Robert Land was sentenced to 20 hours of community service and probation. Naquese Joshua, a former football player from Lakewood High School, was sentenced for robbery on April 15, 2016, before Superior Court Judge Wendell E. Daniels in Toms River, New Jersey. The sentencing took place following his involvement in a robbery incident.
The court is mindful of the situation where you acted as an accomplice with people that were looking to take money from individuals. The state articulated the position of a man who had it pointed to the back of his head, probably not knowing in a second whether he'll be living or dead. That's a serious, vicious, horrible event. Young ladies coming from work being pushed down, seeing people approach them, seeking their money. That's a vicious, horrible, frightening event as well. So I'm going to find aggravating factor number 2. I'm also going to find the only other aggravating factor I'm going to find is aggravating factor number 9, the need to deter this defendant and others from violating the law. There's a need to deter you and some of your friends and other people in the community. You can't be engaging in consuming alcohol, arming themselves with whether a toy or not, seeking out people to rob, which you in fact did. That needs to be deterred. And I give heavy weight to that. A message needs to be sent to other people, regardless of their age, juvenile or otherwise. This conduct cannot be tolerated. Count 1, defendants committed to the custody of the executive director of the Juvenile Commission for a term of 10 years. Pursuant to the No Early Release Act, he has to serve 85% of that before he'll be eligible for parole.
Naquese Joshua was sentenced to 14 years in state prison for his role in a robbery. He was required to serve at least 85% of his sentence, approximately 11 years and 10 months before being eligible for parole. Richard Marcos Taylor, the actor known for his role as Suge Knight in the film Straight Outta Compton, appeared in state superior court in New Brunswick, New Jersey, for allegedly making threats at a South Plainfield bank. The incident occurred in August 2017, when Taylor was accused of threatening bank employees and causing a disturbance. During his court appearance, Taylor faced charges related to threats and harassment.
This indictment was based upon an incident at the TD Bank in South Plainfield when the police were dispatched on a report of a disorderly person. Apparently, Mr. Taylor had become upset with a transaction that wasn't happening as quickly as he wanted it to happen in terms of getting his new ATM card, and their dispute escalated with the teller, and the police were called. When they came in, there was a situation of his being very aggressive, and he was ordered to stop, but he continued to advance, including cursing at the police. And the officer attempted to use OC spray on Mr. Taylor, which missed, fortunate for your eyes anyway. And He was ultimately calmed down by other officers without the need to do that, but he was arrested for the behavior at the bank.
Richard Marcos Taylor was sentenced to a year of probation. Stacy Caster was convicted for her crimes, including the poisoning of her first husband, Michael Wallace, her second husband, David Caster, and attempting to kill her daughter, Ashley Wallace. She had poisoned both of her husbands to collect their life insurance money. The prosecutor's detailed explanation of the case highlighted the severity of her actions, underscoring the intense gravity of the situation as the details emerged.
Let me begin by saying why we're here. We're here because an Onondaga County grand jury has returned an indictment against the defendant. As the judge has emphasized several times, it is not evidence of anything. It is simply a framework by which this case must proceed. I will read it to you very briefly. It's been a while since you heard it. And it's what I must prove to you beyond a reasonable doubt. The first count charges Stacy Caster with the crime of murder in the second degree. And it is alleged here in this county, in the town of Clay, during the time period August the 19th, 2005 through August the 21st, 2005, she intentionally caused the death of David Caster, her husband at the time, by poisoning him with antifreeze. The second count charges this defendant with attempted murder in the second degree. It alleges that on or about the 13th day of December, 2007, again in the town of Clay in this county, the defendant attempted to cause the death of her daughter, Ashley Wallace, by poisoning her with a combination of pharmaceutical substances that were mixed in with an alcoholic beverage. The third count, very, very technical language. I won't read it all to you. The judge will explain the law to you on it all at the end of the trial. But the third count alleges that in December of 2005, after the death of her husband, David Caster, this defendant presented a phony will in surrogate's court in an effort to get all of his inheritance. These crimes, these three crimes that I'll talk to you about, including a fourth not mentioned in the indictment because it did not occur in this county, will be the framework of our case. And now, for the very first time anywhere, despite what anybody has seen, read, or heard, for the very, very first time anywhere in the history of this case, let me tell you what the evidence will show. And I do this, folks, with a calendar because I think sometimes it can be helpful. This is Chuck, August of 2005.
Judge, I don't mean to interrupt, but could we place the exhibit in position so we can also see?
It's just a calendar, Judge. I've tried this in various points throughout the courtroom. If I move it, the jury's not going to be able to see it.
Do you want to move,
I can move that to this portion over here?
Where would you like me, Judge?
Wherever you can see the calendar, if you want to come around here.
It's the early afternoon of August 22nd, 2005. You all know we have a 911 center. The 911 center gets a call that had been referred to another police agency. It's not really a police emergency, but they get a call from a woman who identifies herself as Stacy Caster. She indicates that she wants assistance getting into her house, more particularly getting into her own bedroom, because she's worried about her husband, David Caster, who's in the bedroom, and she's worried that maybe he might hurt himself or he might hurt her. So no particular alarm bells go off. Police respond depending on availability. They probably get 100 calls like that every month. And one member of the Onondaga County Sheriff's Department who responds is Deputy Willoughby. Deputy Willoughby comes up, identifies himself, who he is, and he meets a woman who's sitting in a lawn chair smoking a cigarette, and who he eventually learns is the person that made that phone call, Stacy Caster. She then engages in a conversation with him. She repeats her concerns. She says to him basically, look, I'm worried about my husband. I'd like you guys maybe to help me get in there. And then she begins to fill him in on some of the activities that occurred on Friday the 19th, on Saturday the 20th, on Sunday the 21st, up until the time they're meeting on Monday the 22nd. She points out the location of where her husband's bedroom is within the framework of the house. And she claims that she's now locked out of that bedroom. Okay. Deputy Willoughby doesn't do anything different than probably you would do. Knocks on the door. He hears a TV inside. Still trying to help. He goes outside. It's a nice day. He actually gets one of those little step ladders, and he puts it up next to the window that Mrs. Caster has identified to him as his bedroom window, and he tries to look in, see what the heck is going on here. He can't get any visual response because of the shades. He doesn't really see anything of any moment. And then he says to the defendant, look, I think the best way to handle this is I'm just going to break the door down. Is that okay? The defendant says, sure. Go ahead. She agrees. And, you won't get a sense of how much pressure he had to use, but you'll see the door. And then you sold, what is this, a Tundra? What's that? Another
That's
vehicle?
my truck.
Oh, that's your truck. Okay, well, that's something you bought. All right, we'll leave that out. So we got the insurance company just under $50,000. We got the IRA of $19,000. We got the truck for another $16,000. And then we got the auction for almost $30,000.
That money didn't.
We got the estate of David Caster, check from Mr. Churchill for $60,000, and your executrix fee of $6,000. You made a lot of money on this, didn't you?
No, I did not. That $30,000 from the auction.
Excuse me. Question was asked and answered. This money went where?
The $60,000.
Didn't it?
$60,000 from the estate. Yes.
I got a question for you. Wednesday night and Wednesday afternoon, were you on the computer at any time during that day?
No, I don't think so. I don't remember.
You were asked that question. Then your lawyer asked you like a couple of questions later, do you remember typing that day? And you said, no, absolutely not. How is it that you're certain you weren't typing at the keyboard when you can't remember whether or not you were at the computer?
Well, if I wasn't at the computer, I couldn't be typing.
Well, you didn't say you weren't at the computer. You said you weren't sure if you were at the computer. How can you be not sure whether or not you were at the computer, but you're certain that you weren't typing? How can that be?
I answered the question he asked me.
I know you answered the question. That's not answering the question I asked you. How can you be sure that you weren't typing, but not sure if you were at the computer? Don't you type when you're at the computer?
Yeah.
You can't operate the computer without doing a little of this stuff, right?
True.
Okay. So yesterday you said, in response to this question, were you at the computer on Wednesday? You said, I really don't know. I can't remember, right?
Yes. And
then he asked you, did you type anything that day? And you said, absolutely not.
Objection, Judge. I didn't ask if you typed anything that day.
Well, I'll overrule
You
you.
characterized my question, Judge.
What did you ask me?
I asked her if she remembered while she was on that phone call whether she was typing something.
I stand corrected. While you were on that phone call, were you typing? And you said, absolutely not.
Okay, well, I was on that phone call. No, I was not typing.
Well, how can you be so sure?
I remember the phone call. I've heard it played.
So?
So, I wasn't typing while I
What
was
were you
talking.
doing?
Sitting down, talking to Danny on the phone.
What were you wearing?
Probably jeans and a t-shirt.
I don't care what you were probably wearing. What were you wearing? You remember it.
No, I remember I wasn't typing. I didn't say I remembered what I was wearing.
Now, you just remember that you weren't typing. Right?
Yes.
Because you were typing the suicide note to frame your daughter, weren't you?
No, sir.
And we caught you, didn't we, Mrs. Caster?
No, you didn't.
Just with that little phone call, with a little click, click, click. Mommy, please don't hate me. In the dining room, while her daughter's in her bedroom dying. And Bree comes up and tries to console her, and she tells her to F off. and that's normal. She knows about the Gatorade at the end of the note, but she told you that she only skimmed the first couple of lines, and that's normal. The first time she ever answered her daughter's cell phone and talked to Matt Gandino was on the afternoon she tried to kill her and told Matt not to come over, because that's normal. She phonies up a will, lets her friends almost face criminal charges, but that's normal. And she hides the Lexapro bottle behind some toilet paper with her fingerprints on it, and that's normal. She tried to convince the doctors in 2000 that Mike died of a heart attack. She tried to convince the police in 2005 that David took his own life. Remember the references to ex-wife and psychiatrist and speeding? Take all of that as true. Take all of that as true. You know what? It's the little things. Now she says, no, I wasn't trying to convince him that it was a suicide. Sure she was. You remember? Remember the 7-hour marathon in the garage? And they're drinking Pepsi and she's alone with him, right? No, Ashley. She's drinking Pepsi. What does she say? She says, he didn't want me to drink that Pepsi. He made me go get my Pepsi on my own. What does that tell you? That tells you she's trying to convince the cops that he knew the Pepsi was poison. That's why he didn't want to give her any. That's what she's trying to tell the cops. She's trying to set it up as a suicide. And it almost worked. She's getting good at it. I mean, this is number 2. When number 3 came around, she's a pro with Ashley, because now she's going to do this note. And now this trail of horror and deceit and evil and murder is about to come to an end. Mike Wallace and David Caster, linked forever by a common killer. 2 regular guys. Everybody knows of Mike Wallace and David Caster in their life. Hey, Mike, can you shovel my walk for me? Hurt my back. Or hey, Dave, can you stop at the store and get an extra carton of milk for my mom? She's not feeling. Just guys you meet 1,000 times a day. Only one person shed a tear. Ashley Wallace, killed by their own wife. An agonizing, irrefutable, plain as day type of agonizing death. But now taking you to the peak of that mountain of evidence, I started out by telling you I was at a loss for words to describe this defendant. You can solve that problem for me, because the word for this defendant is guilty. Ashley Wallace didn't have anything to do with the death of her father. She didn't have anything to do with the death of her stepfather. When I was in law school, we took all kinds of courses. Most of them I've forgotten, mercifully. But there was never a course that said Justice 101. Different professors might have had different definitions of it. Might have said it was, this or that or whatever. But nobody ever really said, okay, this is a definition of justice. This is it. But today, right now, right today, justice is sitting in front of me. You are about to bring justice to this.
Now, I submit to you, that's not how an investigation gets run. All right? An investigation should be, we take a look at everything. And if we get a lead that points at Stacy, absolutely, go run it down. If we get a lead that says David Caster actually was suicidal, go run it down. If we get a lead that says, hey, Ashley Wallace might have had a problem with David, a reason to kill him, run that down. Did you hear any testimony about any part of this investigation other than they were after Stacy Caster? No. You did hear one thing, though. When I asked Detective Spinelli, I said, hey, Detective Spinelli, did you ever hear information from the rest of your staff? He was the lead detective. Did any of the other detectives tell you maybe give you a lead that might have pointed at Ashley. And what did he say? I don't know. He's the lead detective in the biggest case of his life, and he doesn't know. Luckily for us, Detective Lashinsky testified, and what did she tell you? She talked to friends and family of David Caster, and what did she say? She developed a lead, and one of those leads pointed at Ashley. Did you hear anything about the police talking to Ashley's friends to try to either rule out or include Ashley? No, because they never did it. When I asked Detective Spinelli, hey, detective, did you know about these big problems Ashley had with David? He says, yeah, I heard about them. I said, what'd you do with that? Who'd you talk to about that? What did he say? He talked to Ashley Wallace. He didn't talk to anyone else about it. They didn't talk to her boyfriends. They didn't talk to her friends. They didn't wiretap her phone. Why? He made up his mind and he ignores it. Now let's talk about Detective Spinelli. Let's talk about how good his investigation was. He gets up there on that witness stand and has the audacity to point a finger at Stacy Caster because, you know, she gives a statement in 2005, a day or two after this incident, and then 2 years later, some of the details aren't exactly the same as in her written affidavit. And now, typically, I wouldn't point at a cop and say, hey, the audacity. My whole family's cops. But I'm pointing the finger at him. Why? Because remember what he told you about that one particular thing where when David fell down on Saturday, and he had a problem because in 2005 in the affidavit, which by the way, Stacy never got a copy of, which he did have, in 2005, Stacy describes it a little bit differently. She has the order of events a little bit off. Now, why do I say he's got the audacity to point the finger at her because of that? Remember what happened to him in the grand jury? Remember what he testified? When he was in the grand jury talking about the exact same thing, he screwed it up. And he screwed it up so bad, he told you they had to stop the presentation and he had to go back and get his report. Now, I'll submit to you this. Do you think that he didn't have his report before he went into the grand jury? Do you think he knew he wasn't? Do you think he didn't know he was going to go testify? What do you think, it was like a birthday surprise? Surprise, detective, come into the grand jury. No. He's a trained professional. And this is a couple of months later with written reports. And he's trained, and he can't keep it straight. And he points a finger at Stacy because 2 years later, with no written report whatsoever, in the context of an interrogation, she mixes up a couple of details. Outrageous. And not only that, Detective Spinelli, I asked him, during the course of hearings in this case, how many times, or I should say, would it surprise you to know that during the course of hearings, when you were asked questions about this case, 32 times he had to say, I don't know, and go look at his reports. 32 times. And this is a detective who has all the reports. And if you don't think he read them before he came in to testify at that hearing, I don't know what to tell you. So we have a detective who's pointing the finger at Stacy because she can't keep a small detail correct. And yet, he doesn't know anything about this case. I asked him, now remember, we know that antifreeze bottle they found with David, we know there was a print on it, palm print, but we know it was not Stacy's. We know that, okay? But I asked him a question, hey, do you know whose palm print it was? Do you know, what did he say? Do you know whether it was Stacy's? What did he say? I don't know. How can he not know? How can he not know in the biggest murder investigation of his career? Whose fingerprints are on what? How does he not know this? I asked him about, hey, did you test this? Did you examine this? What were the results? I don't know. How can he not know what the results are? He's the lead detective.
Have a seat. Good morning. Good morning. All right, Ms. Everly, I have your note that the jury's reached a verdict. If you'd stand for a moment. On indictment number 2007-1271-1, the people of the state of New York versus Stacy R. Caster, as to count number 1, murder in the second degree, what is the verdict? Guilty. On count 2, attempted murder in the second degree, what's the verdict? Guilty. And on count 3, offering a false instrument in the first degree, what is the jury's verdict? Guilty. All right. Do you wish the jury poll, Bill? Chuck?
Yes, Judge.
All right, Kelly, go ahead.
Ladies and gentlemen of the jury, as stated through your foreperson, you have found the defendant guilty of all 3 counts in the indictment. Juror number 1, is that your verdict? Yes. Juror number 2?
Yes.
Juror number 3? Yes. Juror number 4? Yes. Juror number 5? Yes. Juror number 6? Yes. Juror number 7? Yes. Juror number 8?
Yes.
Juror number 9?
Yes.
Juror number 10? Yes. Juror number 11? Yes. And juror number 12? Yes. Thank you.
All right, ladies and gentlemen, on behalf of both parties and myself and the people of Onondaga County, I want to take this opportunity to thank you and you folks who are alternates, your patience too over the last several days when you haven't been able to deliberate. I'm very, very grateful for your patience and your understanding also. Your jury service is over. You're certainly free to go with our thanks. You're free to talk to anybody about the case that you wish, whether it be the lawyers, the press, each other, your families. But I want to thank you really with very sincerely, and I hope stay warm.
Thank you. I'd like to interject, if you don't mind.
And I believe that the sentence I'm about to impose will remove that danger once and for all. Upon your conviction for murder in the second degree of David Caster on count 1 of the indictment, it's the sentence and judgment of the court that you be sentenced to a minimum of 25 years and a maximum of life in the New York State Correctional System. Upon your conviction for attempted murder in the second degree of your daughter Ashley Wallace on count 2 of the indictment, it is the sentence and judgment of the court that you be sentenced to a determinate sentence of 25 years in the New York State Correctional System, to be followed by a 5-year period of post-release supervision. I direct that that sentence run consecutive to the sentence I've just imposed on count 1 of the indictment. Upon your conviction of offering a false instrument for filing in the first degree on count 3 of the indictment, it's the sentence and judgment of the court that you be sentenced to a minimum of 1 1/3 years and a maximum of 4 years in the New York State Correctional System. I direct that sentence to run consecutively to the sentence I've imposed on counts 1 and counts 2 of the indictment. There's a $275 surcharge. Ms. Caster, you have 30 days with which to appeal the sentence and judgment of the court. We are recessed.
Thank you,
Thank you.
Okay. She's in home office. Okay. As soon as I get back.
Stacy Caster was sentenced to 51 years in prison for the murders of her 2 husbands and the attempted murder of her daughter. On March 31st, 2019, Juan Ricardo Hernandez was involved in a road rage incident with Pablo Lyle in Miami. During the altercation, Lyle delivered a fatal punch, causing Hernandez to suffer a traumatic brain injury. Hernandez passed away 4 days later. The jury carefully examined the factors leading to Lyle's conviction for this severe crime.
The court finds the verdict form is legally sufficient. There are no errors or omissions in the filling out of the verdict form. Chris, would you please publish the verdict? I'm here to rule on the defendant's motion for new trial, and the amended motion for new trial, which was filed by the defense, as counsel had indicated, did not raise any new grounds for relief, but merely provide additional case law in support of the motion, in support of the issues that were raised. This court held a hearing last Thursday where both parties outlined all arguments made and provided additional case law in support of their respective positions. Parties were also permitted to file any additional pleadings by close of business Friday, December 9th, to which Mr. Eisenstein, on behalf of Mr. Lyle, did file an additional memorandum of law in support of the motion. This court has carefully reviewed all of the pleadings, exhibits, and applicable law. I've also reviewed my trial notes, the instructions given to the jury. I've considered all of the evidence that was presented during the trial. While defense raises numerous issues for the granting of relief, the court specifically focused on the questions of unduly restricting the defense's closing arguments based upon further evidentiary rulings that the court made during the course of the trial. And I am been on mute that whole time. Excellent. So we're gonna not rewind all that because I forgot what I said earlier. In any event, a ruling here on the defendant's motion for new trial. Defense interestingly cites a couple of cases which I read in some detail. The Aiken case, which has some negative treatment, but not on these issues, as well as the Tipton case from the Florida Supreme Court. And again, focusing on the defense main issues, the court unduly restricting its closing argument, which was the result of the court not allowing certain information to be presented to the jury that the court did not believe rose to the level of proper admissible evidence. Mr. Lyle's statement was introduced into evidence for the jury to consider, and that statement was introduced in its entirety. The court also reviewed the cases, and as I just mentioned, and in Tipton, which was quite interesting, unlike our case, in Tipton, the court failed to address the excusable homicide point that has been made by the defense in their motion for new trial. And that was a significant distinguishing factor between our case and Tipton, because the court did properly instruct the jury in our case on both justifiable and excusable homicide. Also, in addressing whether or not this is a case like the Tipton case or the Aiken case, where there was a claim of a mutual combat, figuratively, what happened in Aiken, which was again quite interesting, what occurred was a battle of vituperation, and I had to look that word up because it was a new word for me. And vituperation means bitter and abusive language. And in our case, it appears, and from the evidence that was presented, it was a battle, a combat of bitter and abusive language. However, unlike Tipton, what transpired from that vituperation or mutual combat was quite different. And in our case, it went beyond mere bitter and abusive language to the point where any combat was not mutual. And in our case, the actions by Mr. Lyle, given the totality of the circumstances, the court does not find were justifiable. For those reasons, and again, after carefully reviewing all of the issues raised, taken individually or cumulatively, the court does not believe that the claims raised by the defense support the granting of a new trial. As such, it is hereby ordered that a judge that the defendant's motion for new trial is hereby denied, done and ordered today in open court, and the court signed the order denying the motion.
Especially in a situation like this. I pray to God every day, so I know that this day was coming. And I pray that this day will bring you closure, and that whatever happens today, you can leave this courtroom with rest in your hearts. That Mr. Hernandez lost his life because of something I did. Something that walks with me. It haunts me when I go to bed. And it's still there when I wake up. Before never wanted any of this to happen.
I never in my wildest dreams could have imagined something like this could have happened. That a life could be lost and so many others affected so drastically in just a matter of seconds and one punch. Today I want to take this opportunity I was denied in the past. Tell you, as much as tell you, Juan Ricardo, that I was sorry. But I am so very sorry from the bottom of my heart. Quiero que lo sepan de mi boca. Que nadie les platique lo que siento. Siempre fue la disculpa más sincera que he ofrecido en mi vida. Con todo mi corazón. Lo siento mucho. I want you to know that it wasn't anything against Mr. Hernandez. I truly thought I was protecting my family. I can say that I've learned a huge and very important lesson. And I'm sure that many others impacted by this have to. I know that you lost someone very important. And I also know there's nothing I can do to bring him back to you. But you have my promise. And I'm going to pray for him and for you with all my heart. God bless you.
This was not an instinct, in this court's opinion. The court believes Mr. Lyle acted with the intention to re-engage and confront Mr. Hernandez. Verbal confrontation, a verbal reinitiation. The evidence shows that the action by Mr. Lyle was an act of violence. One would not think that a punch would ultimately result in an individual, but that punch set forth a series of events that ultimately culminated in Mr. Hernandez's unnecessary death. Mr. Hernandez did not deserve to die because of what occurred that day. Mr. Lyle chose to act in a way to resolve a conflict that, as the jury found and this court concurred, is not protected by the law, was not justifiable or excusable. The medical examiner testimony established that the punch was forceful, that the punch, although not showing outward injury, caused injury internally. And again, how extraordinary and unexpected that would cause the series of events that led to Mr. Hernandez's unnecessary and untimely. Nothing that this court does in terms of punishment, we talk about punishment for an individual, holding them responsible for their actions, is going to ease the pain of the loss to the family of Mr. Hernandez, to the loved ones of Mr. Hernandez, to the friends of Mr. Hernandez. 15 years, 100 years in prison. Mr. Lyle will have the burden and the responsibility of knowing that his actions ultimately resulted in the death of another human being. I found Mr. Lyle's comments sincere, not as an excuse. I believe Mr. Lyle believed what he says, but the law does not excuse that the response that Mr. Lyle had or he perceived in the circumstances that were presented. This court's opinion is whatever threat, if any, Mr. Hernandez might have posed to Mr. Lyle or others, including his family, during those moments, the threat abated, the threat ceased. As I said at the beginning, I have considered everything in this case. I have read hundreds of pages of documents. I have listened to tapes. I have reviewed, and this is throughout the entire proceedings. I went back, I reread all of my notes of the trial, reviewed all of the trial documents and evidence that was presented, considered everything that every individual has not only written to this court, but stated today in court. I have considered as well and respect the information provided by the Department of Probation in their pre-sentence report. I think that you have a wonderful understanding about humanity, everyone who had spoken, both his son and his fiance. And both of you, again, I believe, will continue to honor your father, your fiance, a loved one for all of you by your words and actions, not with anger, not with evilness. And I only hope you can understand that I do believe the punishment in this case that I will impose on Mr. Lyle, I believe will be fair and sufficient. I don't see Mr. Lyle as a future threat to anyone. It was the worst decision of Mr. Lyle's life. And we are judged by our actions. The law requires us all to control our reactions and actions and responses. Again, I repeat, I believe the jury was convinced, as I was, that any threat, if there was any, caused by Mr. Hernandez ceased. There was time for reflection by Mr. Lyle, even if it was a matter of seconds, contemplate his action, which was a confrontation and a punch. This was not a case of mutual combat. How we resolve conflict in an ordered, lawful society, that's the issue. And it's imperative that we take time to consider what has transpired, not making Mr. Lyle an example, because that's not my purpose in punishment for Mr. Lyle. But there are lessons to be learned. How you're going to resolve conflicts in the future, Mr. Lyle, I believe will never be the same as you did that day or as you did before that day. That is what is going to take courage and strength. The court hereby sentences Mr. Lyle to a term of 5 years Florida State Prison, followed by a term of 8 years of reporting probation. Mr. Lyle is required to engage in conflict resolution, anger management classes and teaching. Mr. Lyle is also required to perform 500 hours of community service. I'm not going to dictate the type of community service that Mr. Lyle should perform. I will leave that to the discretion of the Office of Probation. Mr. Lyle's entitled to credit for time he is served in custody. The probationary period, and all should be reminded, is a form of punishment. Mr. Lyle, you will also, again, as I said, be entitled to credit for time served. You will be fingerprinted at this time. I believe we should already have your DNA on file. If not, that will be taken. And Mr. Lyle, you have a right to appeal the judgment of conviction and sentence of this court. You have 30 days to effectuate a timely appeal. I do not know at this time, because it hasn't been brought up until this moment, whether or not you will need the services of a public defender or will continue with private counsel.
He won't, Judge. We'll make sure the appellate papers are perfected. He does not need the services of a public defender. Thank you for asking.
All right, very well. So there is 30 days to effectuate any timely appeal. Again, my heart goes out to everyone.
Pablo Lyle was sentenced to 5 years in prison for the fatal punch he delivered during the road rage incident with Juan Ricardo Hernandez. Lyle was convicted of manslaughter in connection with Hernandez's death. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.